Leading this panel, I have the honor of introducing my friend, Bill Barton. If you know anything about construction, you probably tune in to his weekly, is it weekly or bi-weekly? Monthly webinars. I tune into them. I'm giving him a little plug for them, for Barton Legal. They have outstanding construction speakers every month that you can listen to online and learn a lot more about construction. So when we needed a moderator, we said, let's get Bill. Just to tell you a little bit about him, he's obviously now with Barton Legal, his named law firm, and he's been a partner with Walker Morris, Watson Burton, and DLA Piper. He set up Barton Legal in 2007. He has particular expertise in drafting and negotiating specialist bespoke contracts, whether in relation to wind farms, renewable energy, colleges, standard construction projects. He's experienced drafting amendments to and negotiating not only standard forms of contracts such as JCT, NEC, ICE, but also the FIDIC Red and Silver books, as well as the ICHEME Burgundy, Red, and Yellow books. Bill's experience ranges from industrial developments in Hull to colleges in Stoke and Lancashire, from Scottish and Welsh wind farms to oil tank farms in Ghana, from construction. Guys, he's Mr. Construction. We don't need to hear any more. With that, Bill Barton.
Morning, everybody. I was going to ask you all to stand up to make sure that you're awake. But I've discovered that you are sitting on some of the most uncomfortable seats that I've had for some considerable time, so I'm presuming that you're both awake and numb. I'm just glad I'm not a student anymore. I'll apologise in advance because I'm not multilingual, okay? I don't have a PhD, so I'm clearly, the sort of the thicky of the day. I'm very interested by making perhaps an application to move from construction into the investor state sector, because if they're running for 4 years and those claims, then I'm clearly missing a trick in terms of those costs. Or eight. Yeah. In construction, we've had capped fixed costs, fixed fees, cost budgets for a long, long time. In my practice, nearly all of my work now is fixed fee. And when I see litigation, you can grab it like this. It's a big, huggy friend because it's all on hourly rates. But then the clients say, oh, you will cap it, you will fix it. So what happens now is you chunk it. So it comes in sections of pursuing and fixed costs. So I definitely think I'll be applying to transfer into investor state litigation. Just to see if I've got any potential friends in the audience, can you put your hands up if you either live or your families live north of Cambridge? Excellent. Excellent. So I am the only northerner in the room. So I'm on a hiding to nothing. So I live in Leeds. Okay, so if this is sort of London, here, and then Cambridge, I'm sort of way up there somewhere. It's sort of place where everyone thinks it's cobbles and the trains don't go. Oh, we do actually. You're very hot. Yeah, it is quite hot. It is quite hot. Yeah, normally, anyone out in Leeds, obviously, through the winter, I don't think anyone actually owns a jumper or a coat. I've never seen anybody wearing one. What else? What we're going to talk about actually is words. I think I've swillions of words this morning. What construction, and I think solicitors, those of you who aspire to this incredible profession, our skill is words. You can call it construction, you can call it matrimonial, or anything, you can do any sector. But the skill you're all learning is the use of words. And it's the use of words and punctuation, because you can change a word in a sentence or an emphasis of words, and the sentence has an entirely new meaning. Historically, way back, even before I started work, documents had no punctuation in whatsoever. Every now and again, I see, not having a go, I'll have a little go, I see from some firms documents that still have no punctuation in. Don't get it. I have a simple rule. If I read a paragraph or a clause in a contract and I don't get it in 2 reads, I just send it back. Okay? You should learn to do the same thing. Write in plain English. Use punctuation. You know, you don't have to use legal gobbledygook. Okay? It's in all contracts. We love inventing things, and you'll hear lots of phrases. But just learn to write in just plain English with punctuation. You know, it will make your life a lot simpler. Arguments, that's the other thing you're going to be hearing about. That's the other common theme. It doesn't matter what you do, there is an argument. So hands up, who has never had an argument? There you go. In fact, hands up those of you who argued with somebody about the fact that you're not arguing. Now, we've all done that. How many times has someone said, are we arguing? No, I'm not arguing. And that, again, is the thing. It doesn't matter what you do. So, Jessica, unfortunately, she has COVID. She was going to be talking about climate issues. And I was going to make the point that it's perhaps crushingly sad that you had COP26 in Glasgow, and basically nothing happened, did it? You know, but then you have the war in Ukraine. Excellent. Suddenly, headlong rush to green energy. You know, everybody's now saying, "Oh, actually, no, we don't really want Russian gas and coal." You know, perhaps we will. So it's funny, isn't it? You can have all the world leaders in Glasgow can't make up their mind about anything. Then you have a war, not a good thing. But out of that, there's been more movement towards an environmental and climate policies in most countries than you've had in the last few years. And that's going to fuel lots of changes because the acceleration of change, so even the Tories, not big fan of Tories, you all are, even they may change and allow more wind farms. Then we have Ian, who's going to talk at the end. He's going to talk about shipping issues. And I was going to say, isn't it a good job that we all don't travel by ships? Because whenever I read a shipping case, which is, you know, there's a lot of law that transfers, I absolutely guarantee the lawyers have spent ages, incredibly braining, they spent ages drafting the contracts, making sure they get them. But they have, like us, in the pure construction side, brilliant clients who just completely mess it up every time. So they crash, they send the wrong cargo, they send the wrong boat, they drive their boat into the sand in a canal, you know. So isn't it a good job you don't travel by boat anymore? Karen is going to talk about engineers and how they've done themselves out of a job, which I think is in simple terms, engineers have progressed through contracts from being a very obvious appointment to the employer, and they're trying to move away to sort of pretend that they're not connected with the employer, but everybody knows they are. And as a result, nobody wants to actually entrust the engineer to disputes or disputes to engineers, and that's why you've got all dispute boards growing, because the engineer is just basically seen as a little bit biased. And then Rupert is going to talk about multi-tiered disputes. And this is what I was saying earlier about language. So you think multi-tiered disputes, he's talking about disputes. Actually, he's talking about dispute avoidance. Because one of the things about multi-tiered disputes is they're there to try and help parties to avoid disputes. So you're very lucky to have these three, who are all, phenomenally right. So I'm going to give a little introduction to each one. Karen's looking worriedly.
Well, you gave me one on Thursday, which was hugely embarrassing.
I'm not quite sure you should use that term phrase. So Karen is in practice at 39 Essex. Essex Chambers. She's also attorney at law with full rights of audience in Jamaica, Trinidad and Tobago. She's served as the first lay chairman of the Institute of Chartered Accountants, Insolvency Licensing Committee, council member of the Society of Construction Law. She's a past president of the Chartered Institute of Arbitrators, member of a number of arbitral institution panels, acknowledged expert on all FIDIC forms. Whenever I'm stuck, I call Karen and ask her about FIDIC. She's got that photographic recall. I don't need to send the contract. She specialises in major complex construction engineering infrastructure. She practices globally, counsel, arbitrator, adjudicator, ADR neutral. She's paid at all levels of courts, including the Privy Council. And she's been described in Legal 500 as just the person you want if the battle is going to be hot. Outstanding in her detailed and analytical grasp of her field. If she ever asks you to carry a handbag, don't. It's always incredibly heavy. I don't know what you do. Rupert. Yours is very short. I tried to find more about it. You've got to put more information out there. I've stalked you on Facebook, on LinkedIn. You know, I was going to just make it up, but okay.
It's undoubtedly better than the truth.
Well, I don't think so. So he's recognised in Chambers as superb, knows how to handle witnesses, capable of dealing with anything, excellent combination of French and English law capabilities. Rupert is very unusual. Oh, sorry, there's a pause. Because, sorry, there's my notes. He's very unusual because he also acts as counsel in both common law and civil law jurisdiction. He went to France, he was telling me at break, he went to France to work in Paris for a year, came back 17 years later. Wife and kids were very upset. So, Ian is here obviously because he's ex-Cambridge. You know, I came to Cambridge as a child. Days out, hunting, drinking. Not quite the same, is it? So he's been a president of the London Maritime Arbitrators Association, as I say, he's a graduate at Cambridge University, barrister. He's a member of the Baltic Exchange, member of the board of the Maritime London, member of the arbitration panels of China Maritime Arbitration Commission, Shanghai Arbitration Commission, Shanghai International Shipping Institute. He's been Senior Vice President, International Carnival Corporation. From 2003 to 8, he was on the main board of P&I Club. He's been actively engaged as an arbitrator in maritime cases. He's got experience in commercial and technical aspects. And then just to rub it in, he's fluent in German, French, Italian and Mandarin Chinese. So there will be questions at the end. So could you, and he actually says, just to rub it in, Mandarin Chinese, reading and spoken. Just, it's not passing. So any questions in Mandarin? So we're going to start with Karen. As I said, we are one person down, so we'll have questions, or we'll have questions in between, because we're going to have loads of time. Okay? So Karen can stay there while you fire questions at her, and if you don't think of some questions, we'll think of some.
Okay, I was going to say good morning, which is what my builder said to me last week, and I looked at him very coldly and said, actually, it's after midday, which is how construction disputes go. Never on time, never on budget. But anyway, I'm going to talk to you about this very narrow subject. Have dispute adjudication boards rendered engineers obsolete? Bill's given half the game away already, but I'll try and think of something interesting to say about them. The first thing I wanted to ask you, though, as a group, I wanted to ask you a few questions. How many of you know anything about standard forms of building contract? How many of you have actually heard? I've got one at the back, 2, 3. Oh, yeah, Ben, put your hand down. It's just not fair. Not many. Who's heard of FIDIC? Some. Okay, that's good. Yeah, Ben, you can still keep your hand down. I'll assume you know these things. JCT. Yeah, some. Good. NEC. Okay. Well, I'm going to use FIDIC mostly as an example. And FIDIC has a range of forms of building contract, and they're used in different kinds of international construction projects. And their forms illustrate quite well what I will call the rise and fall of the engineer. So I'll refer mostly to FIDIC. Now, who knows what is the engineer? Who knows what role an engineer has on a construction project? Okay, not a lot. For the purposes of this discussion, the person that I'm going to call the engineer is basically the lead consultant responsible for the administration of the project, of the contract. So in FIDIC, this person is called the engineer. It may not be an engineer at all. It may well be an architect. It may be a very specific kind of engineer. It may be a structural engineer. It may be a mechanical engineer. But they call him the engineer. That person who administers the contract is called the engineer. In the JCT forms, the older forms referred to architect. For a long time now, they've referred to that person as the contract administrator. That person may be an engineer, maybe an architect, maybe a quantity surveyor, somebody trained in contract administration. In NEC 3 or 4, they have a project manager who effectively fulfills the same sort of function as the engineer. In NEC, different kind of contract to the others. NEC is more modern in its evolution, and there we see in NEC that they've tried at least. They have an impartial contract administrator, and that's the person in charge of time, money, and delivery of the project according to the standards in the contract. NEC also has a supervisor, but a supervisor is more of a clerk of works and looks at quality issues in the same way as you would have a clerk of works in a JCT form, or you may have an employer's representative in a FIDIC form, which is not an EPC kind of contract, i.e. A construction contract for works or a design and build contract, but not a turnkey contract. So that's who the engineer is. Key features of the role of the engineer. He has to administer the building contract, and he deals with quality, quantity, time, and money. Those are the 4 things you have to think about. That's what the engineer has to do. In the FIDIC forms, and I'm thinking of all forms of the Red Book, which is the basic construction contract, his role is described as simply to carry out his functions under the building contract. He gives instructions regarding the works, so he can add work, he can take away work, he can change the works. He can issue certificates for extensions of time to the works. There'll be a programme during which the works have to be started and completed. And if something goes wrong, the contractor's going to ask for more time. The engineer is going to evaluate that claim. The engineer also certifies payments. He certifies progress payments. He certifies additional payments. If work is taken out of the contract, then he takes money out of the contract. The engineer's role is to deal with claims and render engineers' decisions or determinations on issues which the contractor brings forward concerning the work. So, and it's this last bit, really, the dealing with claims and rendering engineers' decisions, which is the subject of this talk in particular, the issue really that we're looking at. So originally the role of the engineer, in the early FIDIC forms you can see, and I'm only going back to 1987, but FIDIC forms came about since 1957, I believe. The engineer was very much the first tier of dispute resolution between the employer and the contractor. And in the early forms we can see from the slide that the engineer's duties were specifically to balance the interests of the parties in administering the contract. You see that also in the JCT forms, and the JCT really never lost that, but we'll see with FIDIC that it changed. And here, the engineer's duty is to act impartially. And these are just clauses in the 1987 form, which I'm just noted here, where he deals with claims notified under clause 53, certified payments under clause 60. The really important point here is that he made engineers' decisions under clause 67 of that contract, and those decisions concern the claims brought forward by the contractor. And the engineer in 1987 was the single buffer, the thing that stood between the contractor or the employer and the right to go to arbitration. And you needed an engineer's decision in order to go to arbitration. And there is some law on it. The difficulty with FIDIC forms, and I'll tell you this if you think that you might like to look into it a bit more, there's very little jurisprudence on it, because throughout history, the FIDIC forms have always provided for arbitration of disputes. And therefore, the only time that the FIDIC form provisions get in front of the courts is when there's a challenge to an arbitral award. And for the longest time, it's very, very difficult to challenge an arbitration award. Those of you that are dealing with arbitration will understand that there are very limited provisions. Certainly in this country, under the 1996 Act, there are 3 sections of the Act that you can actually try to challenge an award. I've tried to do it several times. I wrote a big paper on it more than a decade, probably 15 years ago. And then about 97% of the cases I looked at, the challenges to the award failed. So you do not see much jurisprudence concerning the FIDIC forms or the FIDIC provisions because of the restricted ability in this jurisdiction, but mirrored in many jurisdictions around the world, the restricted ability to actually challenge an arbitration award. So in 1999, we first see the change to the FIDIC forms, which seriously brought into being, dispute adjudication boards. But if you look at the role of the engineer in 1999, there is a change. There's a change in the provisions. In 1999, unless the contract said otherwise, the engineer is deemed to act for the employer. He gives instructions in the same way as before, but whereas before they were saying they had to be in writing, there's slightly more flexibility, where practicable in writing. And I think really that's just something that reflected what was going on in the industry. It wasn't a novel thought that actually it's a good idea for him not to give things in writing, because actually the good idea is for him to give things in writings. But he deals with time and money claims, and those are the provisions in the 1999 form. And he renders, and this is the only real mention of fairness or impartiality, his obligation when he makes an engineer's determination, so it's no longer a decision, is to render a fair decision. And I say there at the bottom, because you can see from the contract that that's the case. The engineer in 1999, in the new Rainbow suite of forms, the red and yellow books, he had no express duty in the contract to act impartially. And I was talking the other day about the engineer, in fact, in one of Bill's webinars, and somebody wrote in the chat, he said, well, you know what, that just reflects current practice. And actually, you know what, I think in 1999 that did reflect current practice, because most people, certainly contractors, had very little faith left in the idea that the engineer would act independently and impartially. Now, roll forward to the next edition of the FIDIC forms, and I'll stick with the engineer and I'll come to the DABs in a moment. The engineer shall be a professional engineer. Well, I was on FIDIC's advisory panel. I'm a friendly reviewer of the 2017 forms when they were being drafted. And I put my hand up and said, but, you know, I do these contracts all over the world. Why does it have to be an engineer? And somebody probably said, duh, we are a federation of international consulting engineers. Of course it's got to be an engineer. But actually, you see lots of amendments to those contracts, and I've seen several where the engineer is not an engineer at all. But in this newest iteration of these forms of contract, they said the engineer will be a professional engineer. So if you want it to be somebody else, you've got to start playing with the contract. And once you want to start playing with the contract, you're playing with fire. But His obligation in 2017 was to act as a skilled professional and be deemed to act on behalf of the employer. Now, the second half of that stipulation is one that everybody has understood for many years. But act as a skilled professional struck me as a recipe for litigation or arbitration or a DAB adjudication decision. But anyway, that's what they wrote. And then the engineer's role as a dispute resolver is to consult to reach agreement so he can bring the parties together and have a conversation, or if they can't reach an agreement, and presumably if they've referred a matter to the engineer, they haven't reached an agreement, to determine any matter or claim. And his obligation when he's operating to determine any claim or matter that's raised with him is to act neutrally. And in those circumstances, the contract provides that he won't be deemed to be acting for the employer. But I ask you, given the way that the role has evolved or not evolved over the last 30 years, 40 years, how much confidence is a contractor going to have in that level of neutrality? So what has happened is that they've invented this thing called a dispute board. Now, it is an American invention, and I have to say, although I'm quite critical of the way that dispute boards have come forward and how they've really diminished the status of engineers on projects, they are really effective for large-scale projects. So it's a 1960s US-led dispute adjudication process, and what they did was brought together panels of independent experts. They were appointed at the beginning of the contract, very early on. They tended to be standing panels rather than ad hoc panels that you could just hire when a dispute arose. So they put them in place at the start of the contract. They visited to the site, they understood the contract documentation, they had meetings with the employers and the contractors and the consultants so that they were constantly familiar with the project and the issues as the project rolled along. And they had their own powers, they were able to hold meetings, and they dealt with issues as they arose on site, right there and in the moment. And that was the value of them. That was the beauty of them, because you didn't have to rely on recollections. People didn't need to remember anything because they were in the moment. So all of the issues that they dealt with were determined in real time. And then, so I posed the question at the bottom, why is the DB more potent than the engineer? Well, these are the key obligations of dispute board members, and I've noted there the FIDIC provision. You find it in the general conditions of the dispute adjudication agreement, which is appended to the standard form of contract. But what FIDIC says is that dispute board members have to be independent of the employer and the contractor, and that is why they are more potent than the engineer. They have to be impartial, and they have to remain so throughout the duration of the appointment. And for those of you that know about arbitration, you might look at that and you think, aha, an adjudicator, an arbitrator, what are the key qualities of those people? Exactly these qualities. So dispute board members have to be available, they have to attend meetings, they can attend hearings, they give advice and opinions when required. And in some of the contracts, they actually go on to give formal decisions, like a mini arbitration award, really. They consider all the evidence and they render a decision. So the 1999 FIDIC Rainbow Suite, I've just put up there. Yeah? So I'm looking at the same thing as you're looking at. It would be a nightmare if it was different. I just thought, I'll just check. So 1999, the Red Book. This is the way it worked. So in 1999, there was a new dispute resolution regime, and DA's decisions replaced the engineer's decision. And it was all set out in clause 20 of the form. So what you had in clause 20.1, clause 20.1 was the claims provision. So there was a different claims provision for the employer than the contractor. So really 20.1 was about contractors' claims. So the engineer would make a first determination of claims. And if you didn't like it, you gave a notice of dispute and you went off to your dispute adjudication board. And in 1999, it was called a dispute adjudication board. It's now called something else, which I'll get to. And you could take any issue to the dispute adjudication board for decision. In 1999, you had the option of having ad hoc and you had standing DABs. We'll see now that the idea is that you should always have a standing DAB appointed from the beginning of the contract. But the obligations of the DAB members, whether they were standing or whether they were ad hoc boards, they still had to have all the provisions I mentioned a few moments ago. They rendered decisions, and unless they were challenged by a notice of dissatisfaction, then the decision would become final and binding. So there would be no further arbitration, or in some of the other forms of contract, there would be the option of litigation, depending on the party's choice. So there would be no recourse to arbitration if you allowed the decision to become final and binding. So if you saw the decision, and even if you didn't like it, if you said nothing about it within the time frame allowed, that's it, you're stuck with it. But that is one of the beauties of adjudication, actually. Sometimes, because it's early, because it's quick, you get a decision. It's not really what you want, but actually it's probably the best you're going to do. So go with it and carry on with the works. There's a provision in the 1999 form which says, if there is no DAB in place, parties may proceed to arbitration. And they say if there's no DAB in place because their remit has expired or otherwise, then you can go to arbitration. And there is some jurisprudence around that particular clause, and that's quite interesting. I've got a case in the Court of Appeal in Trinidad at the moment, precisely on what does that mean. What are the circumstances? What does otherwise in that clause mean? Is a DAB's decision an absolute precondition of a right to go to arbitration? And if it is, then how do you interpret that clause? Anyway, that's just by the by. So we should look at the relationship between the engineer and the it's now called a DAAB in 2017, and that is because it is a dispute avoidance and adjudication board. So you see even more where the engineer would bring parties together and get them to try and resolve something. Now the DAB can do the same thing. There is obviously some rigidity around the ways in which the DAAB can actually use its dispute avoidance powers, because ultimately, if it actually has to render a decision, it doesn't want to impugn its independence and impartiality. So, but for the engineer in 2017, more focus on consultation to reach agreement before he goes on to make a decision. Still the obligation to make a fair determination. There are very clear time limits within which agreements and determinations have to be reached. And that obviously reflected a need, because in the earlier forms, the engineer's determinations just could go on and on and on. But actually, FIDIC has tightened up on all of those things and now put a quite tight timetable around it. Well, some people will say it's a bit lax, but actually it is quite tight. If you're on a big infrastructure project to pause and deal with these things, you don't have a lot of time. Now, the agreements and the determinations of the engineer can also become final and binding if the parties accept them and there's no notice of dissatisfaction issued concerning them. They're final and binding, so you have no right then to go to the dispute board, and you have no right, of course, to go on to arbitration after that, because effectively you've compromised the dispute. You have 28 days to issue a notice of dissatisfaction, and as I say, on a big project with lots of people to consult, that's not a huge amount of time. If challenged, though, if you issue a notice of dispute, then the engineer's determinations may be referred to the Dispute Adjudication and Avoidance Board for a decision. Now, what about the engineer's obligation vis-à-vis the DAAB in 2017? The engineer is obliged both to cooperate with the DAAB and also to give effect to the DAAB's decisions. Now, DAAB's decisions is likely to be reflected in an order that there'll be a certificate extending the time for completion, or an adjustment to the contract price. More money for the contractor is the usual ambition, but, you know, maybe less. But whatever it is, engineers got to give effect to it. And the way in which you secure the cooperation of the engineer in giving effect to the DAB's decision and in cooperating with the DAB is through the engineer's responsibilities to the employer. The employer is responsible for ensuring that the engineer cooperates and gives effect to DAB decisions. Now, avoidance roles, and I've picked up the FIDIC role, but I've also mentioned NEC and JCT here because this is certainly a bandwagon that everybody is now jumping onto. So in FIDIC, 2017 Rainbow Suite of Forms, Clause 20 deals with claims and disputes, and especially Clause 21.3, the DAAB deals with dispute avoidance. And I've already talked about Clause 3.7 and engineers' agreements, but the DAAB role is much more structured. There is a DAAB agreement, says what the DAB members can do and what they can't do. And as I say, the point of that is to try and preserve the integrity, the independence of the DAAB members. NEC 4 in 2016 introduced a new option into its forms of contracts, and it has a dispute resolution services contract. And what that has under option W3 is a dispute avoidance board. And the dispute avoidance board issues recommendations if the parties can't be brought to an agreement. And a dispute avoidance board recommendation is a precursor to your right to go on to arbitration or litigation, if that's what the choice is. JCT in 2021 produced dispute adjudication board documentation, and it has one DAB which is for all purposes, and that is clearly something that needs to get before the courts. I did write a paper on this last year, and it really is quite a complicated thing they've put together, and it's not clear whether by the structure that they've produced that they will be able to preserve the integrity of the dispute adjudication board. For example, in England, where we have statutory adjudication, there are all kinds of issues that might arise if they have a dispute adjudication board dealing with those. So the conclusions, for me, the exam question. Yes, we still need engineers to administer the contracts. There is a loss of status, I think, for the engineer as an effective interim disputes mechanism. And that loss, in my opinion, is probably something they're never going to get back. The DAAB, though, fulfills only part of the engineer's role, and that part, of course, is dealing with disputes. There is around the world, and seriously around the world, in a number of jurisdictions that I've worked in and work in Asia, in the Middle East, in the Caribbean, and in Africa. I was talking to a colleague about DABs in Africa. Although we both think they're good ideas, there is an unwillingness around the world to engage with DABs, and because they fear a duplication in roles and in costs, delays, and all sorts of other things. So the real question now, having told you that the engineer has had to give up some of his status to DABs, the real question is now, what next? Because we've seen the engineer lose status. We've seen the rise and rise, really, of the DAB and the DAAB. And they are more prescribed, they are more formalised. Every time we see a new form of contract, there's a bit more that they must do and a bit more that they mustn't do. You can challenge them now. So we see all that. And the question is that going to be enough? Or will it be replaced with something else? And if it's going to be replaced with something else, what will that be? And I think Rupert is now going to tell us.
Just before you go, are there any questions or parents? I know you're shy. I had one text through to me. In terms of the selection of DABs, Karen,
Yeah.
briefly, can you tell our audience
How
parties selected the members and what the members might be? It's very briefly.
Yeah, so membership of the DAB, if there's a 3-panel DAB, and you can have any number you like, you just put it in the contract, but assume 3, you're likely to have a lawyer, but may or may not be the chairman. You'll certainly, if it's FIDIC, you'll have at least 1 engineer. You might have, depending on the nature of the contract, so if you had a big, if you're building a big energy plant, for example, and you're using one of the FIDIC forms, you may have a civil engineer, and then you may have a mechanical engineer, some kind of special engineer. So it will vary according to the contracts. According to appointments, sometimes, very often, each party appoints 1 and they find a chairman, pretty much like an international arbitration panel. In FIDIC now, there is a default provisions, because what parties would do is they'd put the DAB provision in and then they wouldn't appoint the DAB. But in the recent FIDIC forms, they now have a default mechanism, and FIDIC will, or whoever the parties put in the contract appendices or data, they'll say who they go to have a default appointment, very much again like arbitration. If you don't agree your arbitration, the ICC or the LCIA, somebody will appoint the arbitrator for you. So they have default provisions as well.
Any more?
There's 2, you see, there it goes.
My question is in the context of... Is that right?
Yep.
Great. My question is in the context of COVID and the current war in Russia. I'm interested to understand whether it's an engineer or a DAB or a DAB, in practice, whether those guys resolve force majeure issues for the parties, or whether they escalate onwards to arbitration.
They deal with everything. So if there's a force majeure provision, which there is in FIDIC, and there'll be an apportionment of risks of all kinds under the FIDIC forms, I mean, that's a whole other conversation. But they are part and parcel of the standard form, and so they would go to a DAB, DAAB. Yep, absolutely. I mean, I suspect that down the road we may see a situation where, like we had the Iran-US claims tribunals, I mean, somebody will set up, I suspect, a very specialised board, panels of arbitrators or dispute board people to deal specifically with claims arising from the war. I mean, that's just a guess, you know, but that would seem to me to be sensible. But yes, the DABs would deal with them.
At the back, top, left,
Hello?
For the development process of the standard form of contract, it's clear to me that there has been a conscious push for the parties to resolve the dispute amicably before they reach the final stage of arbitration. So my question is, based on your experience, how much, in terms of percentage, how many disputes get resolved at the stage of DAB or DAAB? And the second question would be, do you think the winter of arbitration is coming, given that there is more channel for dispute to be resolved?
Is it good? Is
Sorry,
it
did you say the winter?
the winter of arbitration?
I love that. I love that.
It's like the winter is coming.
Winter is
take
coming.
the right to steal that as a heading. Winter of arbitration.
Winter is coming. I have to say, well, adjudication in this country, there is a statutory adjudication system, which you may or may not know about. But certainly when adjudication came about here, it signalled the winter of domestic arbitration in the UK. Nearly all disputes are resolved through construction statutory adjudication, and there is more jurisprudence coming from the courts through enforcement of adjudication decisions than there ever is these days from challenges to construction arbitrations. Very little construction arbitration now of domestic disputes. There's also here more of a thing about going to litigation rather than arbitration. Arbitration is no longer the default mechanism. Internationally, it's a very different picture. Apart from the fact that a lot of people around the world, a lot of contractors, a lot of employers don't like DABs, international arbitration is still the default mechanism for the resolution of disputes. I think I'm slightly treading.
That's where Rupert comes in.
I'm gonna, but that's a good question.
Karen.
Brilliant. Now, definitely good afternoon. Well, it's a pleasure to be back here. When I was here first, this building didn't even exist. I sympathise with Miffany saying that when she walked in here, her stomach turned. I remember my stomach turning, but in the old faculty on Silver Lane. And it turned even more, though, when I walked in here and I saw a picture of my Director of Studies, Sir Christopher Greenwood, now Master of my college, standing there. It reminded me to sharpen up my game if I possibly can. Anyway, it's a pleasure to be here, and I'm going to talk about are multi-tier dispute resolution clauses more trouble than they are worth? So first of all, what is a multi-tier dispute resolution clause? Well, it's like this, isn't it? That'll remind us that it's lunchtime. It's a thing of beauty, of many layers, with fruit and goodness running through it. And I often hear that people to whom you speak don't remember what you say, really, but they do remember how you made them feel. And I hope that in some kind of gentle, fuzzy way, this makes you feel good about today's talk. So, in the old days, or at the start of everything, there was arbitration or court. And in an international context, it was mainly arbitration. Now, the trouble about arbitrations is that they are slow to get off the ground, and they're long and expensive. And so what you saw time and time again was that the contractor would go in and do the project, would run into claims of the type that Karen described, so incurring additional costs, delays, etc., and would go to the employer and say, or the engineer, and say, please, can I have some extra money? And the engineer, acting for the employer but fairly, would say, nah. And so then you'd have, then the contractor's only recourse would be to go to arbitration, and that would typically not give a decision until the very end of the project. And what the contractor would usually do is store everything up, and the employer would store everything up until an arbitration right at the end. But what that meant is that the contractor bears all those additional costs on its own through the course of the project. Now, then they said, well, we can do a bit better than just arbitration. Let's introduce a phase of negotiation prior to going to arbitration. So typically you often see clauses saying that if any dispute arises, the parties shall attempt to negotiate for a period of, say, 30 days. And you have variants around that of good faith negotiations or negotiations at a senior management level, but a period of negotiation. And then we say we can do better than that. How about an interim expert adjudication, a dispute adjudication board, a dispute avoidance and adjudication board, which will give a binding a decision, but you could also have a non-binding expert opinion on a particular subject. And then you see people saying, well, we could also introduce a level of mediation. Who here has done mediation? Yeah, don't you love it? It's a form of facilitated negotiation. It's very effective when the two parties are really do have a genuine interest in resolving a dispute. And so now you see clauses that are permutations and combinations of all those things. Very typically, you often see negotiation, dispute adjudication board, and then arbitration, but with mediation as an option on the side. Now, these are all good things. They encourage settlement at an early stage. An adjudication or a DAB can provide a sometimes they're called quick and dirty, but let me tell you, the people who are running these dispute adjudication boards are handing out generally very high quality decisions in a short space of time, and it's not dirty at all. These are really serious things going on. And typically, if you have won or lost before your dispute adjudication board, you're going to win or lose in the same proportion in arbitration. So these are very useful. And importantly, these decisions are, as Karen explained, contractually binding. Even if contested, they are contractually binding unless and until overturned by the arbitration award. So that means that even if there is an arbitration going on, the contractor, let's say, who's been successful in at least part of the claim, can, in this country, go straight to court and ask for summary judgment on the adjudication decision. And in arbitration, you see more and more now, the contractor starting the arbitration and saying, look, before we go into the detail on the merits, I want, please, a partial award finding that the employer must comply with the decision of the dispute adjudication board pending the result of the arbitration, and without prejudice for the right for the tribunal ultimately to change its decision if it wants to. But the contractor says, I'm entitled to a partial award or an interim order forcing the employer to comply with the dispute adjudication board decision. It's very useful. It saves time and costs for both parties. It protects the cash flow for the contractor. Remember, under the old system, the contractor was bearing the costs all the way through the contract. With a dispute adjudication board, you may have 100 claims, let's say. Contractor's going to win on 50 of them, let's say. At least for those 50, the contractor has a potentially enforceable decision, a means of getting cash flow for part of its claims during the course of the project. And that is also one of the main reasons why employers in the far-off countries that Karen described aren't necessarily great fans of dispute adjudication boards. And a dispute avoidance board can avoid disputes altogether. Parties who know that there is a group of sensible people who are going to resolve a dispute very quickly are strongly encouraged to act reasonably in the first place. So we see dispute avoidance boards really fulfilling their purpose. And these forms of multi-tier dispute resolution clauses are increasingly popular. In the Whiting case, Queen Mary survey in 2021, we see that 59% of users like international arbitration together with ADR, and that's up on previous years. So these we like these systems. We like this multi-layered cake. But there are risks and pitfalls. First of all, at the contract negotiation stage, it can be kind of painful to negotiate a complex multi-tier dispute resolution clause. It was easy to stick in the ICC arbitration clause on its own. Adding in levels of alternative dispute resolution mechanisms can be a little bit painful. And even if you're successful in getting your clause into the contract, there are problems. So first of all, there's the risk of the party who just simply refuses to participate in any of the initial steps. And so I'm thinking of an example in a case where I was an arbitrator for a road project in Slovakia on the FIDIC Red Book. The Slovakian Ministry of Transport just simply refused to participate in the steps leading up to in the initial steps, so in the negotiations and in the dispute adjudication board process. And so the contractor claimant still had to go through that process before they could get to arbitration. So those are additional steps. There is the party who does participate but creates difficulties in establishing the DAB. There I'm thinking of a case where I was acting as counsel on a project in Riyadh, where the consortium agreement between the parties provided for one DAB. The design contract provided that the dispute resolution mechanism would be the consortium agreement applied mutatis mutandis. Bill's lesson, write simple, don't write Latin if you can avoid it. Right? But applied mutatis mutandis, that led to a dispute about whether, with these two contracts, whether there should be one DAB covering them both, or two separate DABs, and it should have been a standing DAB under the first contract. The parties didn't set it up. So as a result, when you had a dispute, you can imagine that whatever we said, the other side said the opposite, and there was an additional argument. Now, in the end, we got through it and we won, but it's additional costs for time and costs for everyone. There have been some recent cases in the English courts which have dealt with the question, what happens if a party doesn't comply with the time limits, for example, on either the period left open for negotiation, or in the second case, the NWA case, there was a provision for mediation. One side refused to participate in the mediation and then said, well, you should have done mediation, you didn't. So now you can't go to arbitration, sorry. Now the English court in both cases provided that that was not a question of jurisdiction of the tribunal. The tribunal could still go ahead and hear the case, and it was a question of admissibility of the claim before the arbitral tribunal. So at least the question's going to be resolved by the tribunal, and in both cases I think the tribunal went ahead to find it had jurisdiction and the claim was admissible. But potential difficulties. And then, of course, you can have a challenge to the admissibility of the claim in arbitration. Another example, a case in Vietnam where, with a distorted FIDIC, as Karen said, playing with fire when you distort the model, the employer there had simply deleted the provision related to DAB, but left in the arbitration clause, the clause that says you can only go to arbitration 56 days after a notice of dissatisfaction in relation to a DAB decision. So then when we went to arbitration, the other side said, you can't come to arbitration because there hasn't been a notice of dissatisfaction in respect of a DAB that doesn't actually exist. So again, that can be a additional cost or additional issue that you have to resolve. How do you avoid the pitfalls? Nearly lunchtime, don't worry. Drafting your clause, keep it simple is my advice. Follow the models. Now, FIDIC has become more and more complicated to follow. I'm afraid I personally have got a little bit stuck on the 1999 suite, which I liked and had a relatively simple set of provisions. It's kind of hard to take the 2017 clauses and put them into any other purpose. The ICC has got a quite simple user-friendly standard. I like your 2-minute notice, but I've noticed that you only hold up the 2-minute clause, so it's like a never-ending 2-minute. It never goes to time is up, you're finished. But I will finish within the 2 minutes. And then once you've got a clause, apply it. Read it. Sometimes that is a problem. In practice, the team that negotiated the contract then says, thanks very much, flips it over to the project team and walks away. And the project team says, thanks for the contract, but doesn't actually then read the clause. So set up your standing dispute adjudication board. Follow the steps in the contract. Follow the time periods in the contract. And if you've got a period of 30 days, for goodness sake, start your mediation or your negotiations 30 days before your limitation period runs out. Otherwise, you make difficulties for yourself. And then my last point is keep going. Generally speaking, the party which is in the wrong generally pays in the end. And although you have incurred additional costs, you can claim those costs as damages, I think. Some people may differ, but I think in the arbitration at the end. Mel has an excellent idea of liquidated damages. I think you can get general damages. I'd hate to try and fix those damages in advance in a clause, but
the argument is if you fix it, then it allows both parties to negotiate how much they value each step of the dispute resolution clause. So that way, instead of trying to figure it out after the fact, if I say, okay, I value having these negotiations or mediation by a certain amount, or we can set it at a number where I know if the dispute is over that, I can essentially forfeit it to just move it along.
Yes. So if you can fix an amount, then great.
Right.
And it may be workable in certain situations. So otherwise, keep going. But the short answer to my question is, are multi-tier dispute resolution clauses more trouble than they are worth? My answer is no. Thank you.
Any questions? Yes, the hesitant hand put up at the back there, don't be shy.
Goodness.
First of all, thank you for an extremely insightful presentation. My name is Zip Shah. I'm a master's student at CUArb. And my question is, I understand there are some jurisdictions where DAB decisions are directly enforceable. Some of them, from what I recall, are the UK and Malaysia. So my question is twofold. If a party that is dissatisfied has sent a notice of dissatisfaction, but arbitration has not commenced, but is likely to commence, what is the impact that the arbitration will have on the enforcement proceeding? Mm-hmm. And well, the first question is there an impact? And the second question is, if so,
what is it? Well, so I think in both the cases, in those jurisdictions where the courts have agreed to enforce DAB decisions. Now, what they're allowing, in fact, is a party who has got the decision to bring a claim in the court on the basis of that decision and on the basis of the contractual obligation to give effect to that decision, even if there are ongoing arbitration or even if the arbitration has not started. So the starting of arbitration for cases in those jurisdictions will not affect the enforceability of the Dispute Adjudication Board decision. And I think the same is true in, well, I suppose if you've got arbitration in your contract, you can go directly to arbitration and ask for enforcement of the DAB decision without reopening the rest of the dispute.
And then there's a question.
My question is about whether you've ever come across, or in your opinion, is it possible for a risk that a multi-tier dispute resolution clause could prejudice the validity of an arbitration agreement, because some jurisdictions require parties to have like a decisive net exclusive arbitration agreement, and in that layers of those tiers of dispute resolution clauses, like would maybe one tier kind of prejudice the validity in certain jurisdictions?
Yeah, I think no, it shouldn't. I mean, I can imagine. I suppose there could be jurisdictions that could take an absolutely crazy approach, but so long as your tiers are distinct, and the tiers that I described in one of the slides at the beginning, they're very distinct tiers with different functions. None of them prejudice the arbitration agreement that comes at the end. Where you do see contracts, unfortunately, where you have both an arbitration clause and a clause purporting to give exclusive jurisdiction to a court. And that can cause complications. But that's another story.
Thank you very much.
Thank you, Rob.
Well, ladies and gentlemen, I stand between you and lunch, and even if your lunch is not going to comprise the rather delicious cake that Rupert put in front of you, I will try to be brief. As one, I think it was a sketch developed by some members of Cambridge Footlights said some years ago, now for something completely different. We, as arbitrators, tend to exist in different bubbles of our respective disciplines, And we may find that those who exist in the maritime space have a very different view of themselves and of other arbitrators than the arbitrators in those other disciplines themselves. It was fascinating to hear at the beginning the presentations by the four speakers who spoke about investment treaty arbitration, a subject about which I know extremely little. It was quite fascinating. Had this been available to me when I was a student at Cambridge, I'm quite sure that I would have gravitated towards that discipline. But when I was a student here, and one of the things they didn't tell you was I'm probably about the oldest participant in this seminar. One has to be very careful about what you put out on the internet these days, and I'm not going to be inviting any questions in Mandarin, thank you very much. But when I was a student here in 1972, the only form of international arbitration was shipping arbitration. Investment treaty arbitration hardly existed. The sort of international commercial arbitration which one now speaks of in the Queen Mary survey and White and Case survey didn't exist either, or was very, very rare. But there was a strong tradition, in fact it goes back several hundred years, of arbitration in the maritime space. I'm not going to talk about arbitration in the maritime space generally. I'm going to try and focus my remarks on shipbuilding, which is a form of construction. And my talk briefly will be more like a sandwich than a cake, in that I'm going to talk very briefly about an introduction to maritime arbitration, why it's important, why there's rather a lot of it. And then I was asked to talk about some black letter law, and I'll try to contrast some principles involved in shipbuilding arbitration with those which apply in construction cases, in the proper sense, or civil engineering construction cases. And then I'll round off by talking about differences in the arbitration of shipbuilding cases and civil engineering contracts. Well, you'll see in front of you a ship. Most of you will be fairly familiar with that. It's fairly incomplete. Looks like a bulk carrier to me. And I have to now figure out how to get to the next slide. Generally, in the maritime space, most contracts for marine transportation, whether they're shipbuilding contracts, charter parties for the use of ships, are subject to arbitration. And arbitration cases, as I think was said by one of the previous speakers, have contributed enormously, maritime arbitration cases that is, contributed enormously to the development of English contract law. If you look through the law reports, you will find that very, very many cases over the last 100 years, I would say, stem from maritime arbitration cases. There is a significant crossover, and we'll come to this later, with land-based construction and civil engineering contracts, but there are very, very significant differences. The cases involving maritime contracts also provide classic examples of conflict of laws situations, because these contracts are almost inevitably international. And LMAA arbitration, and I represent the LMAA in one sense. I'm a full member of the LMAA. I used to be the president. Unfortunately, our prime president can't be with us today because his wife has COVID. Thought it better not to infect you all. But LMAA arbitration is a prime example of ad hoc arbitration, and is the type of arbitration which is most used internationally in the maritime space. And to give you some idea of the volume of these cases, in the LMAA, and I've taken 2018 statistics because these were statistics which were submitted to the Supreme Court in connection with the case of Halliburton and Chubb, which some of you may be familiar with, which concerned possible bias on the part of arbitrators. And we had a big interest in this case, and so we gave submissions to the Supreme Court and presented statistics. And so these are the comparative statistics for 2018. And in that year, or I'm sorry, over the taking an average over the years 2014 to 2018, there were some 1,700 cases which were submitted to LMAA arbitration in the maritime space. These are not all shipbuilding contract arbitrations by any means. GAFTA, which deals with commodities such as grain, coal, and so on, had 799 submissions. The LCIA, which probably most of you are familiar with, had by contrast 305. The ICC, which you're probably also very familiar with in construction arbitration, had 1,842 globally. So the LMAA They may not all be as big as the ICC construction cases or other cases, but had twice as many as the ICC internationally. And in terms of the numbers of awards rendered annually, the LMAA produced about 500 awards against GAFTA's 180, 56 in the LCIA, and 512 in the ICC. So you can see the numbers of maritime arbitrations are pretty big. And if you look at it as a cake, it's not, I'm afraid, as delicious as Rupert's cake, but or a pie in this case, I suppose. LMAA arbitration shown in blue there, taking comparative statistics in London arbitrations in a year, make up the vast majority of that pie. And GAFTA comes next. After that, the GAFTA, and then LCIA, and then ICC. And then if you look at this internationally, the LMAA has about 1,700 new maritime cases. The Hong Kong International Arbitration Centre, 47 in the year I looked at. The Singapore International Arbitration Centre, 72, usually cases where the parties had not agreed on the sole arbitrator, as a result of which the SISC became the default appointor. The Singapore Chamber of Maritime Arbitration had 56. The Society of Maritime Arbitrators in New York, which used to be a serious competitor to London but is no longer, had about 70, and the Chambre Arbitrale in Paris about 50. So you can see most of it comes to London, and if you look at it in that way, then you can see the preeminence of London in this space. Well, going to shipbuilding contracts more specifically, we have, like Karen explained in the civil engineering space, particular forms of contract which really are the go-to contracts. And these are really two. The Shipbuilders Association of Japan form and the New Build Con form, which has been developed by BIMCO. BIMCO is the Baltic and International Maritime Consultative Organization based in Copenhagen. And of these, the New Build Con is the more recent, but it has not really gained very significant traction. And that's probably because it is seen as being rather more owner-friendly than the SAJ form. The SAJ form is almost invariably modified because, not surprisingly, being the form of the Shipbuilders Association of Japan, it provides for arbitration in Tokyo. And not many people go to Tokyo to arbitrate. So even if you're building ships in Japan, you will probably find that the arbitration clause will provide for arbitration in London and for the shipbuilding contract to be governed by English law. And the prevalence of English law in shipbuilding contracts is startling. Something like 95% of international shipbuilding contracts are governed by English law, and probably 90% of them provide for arbitration in London. And a very significant proportion of those provide for arbitration under the rules of the LMAA. So you've heard from Karen, I won't go into the standard forms of civil engineering contracts. These are really quite different. Now, one of the differences, I think, and most of the differences really stem from this. Although we're talking about construction, you're talking about an employer who is, in the shipbuilding contracts, the buyer of the ship, who pays the money for the ship to be built in somebody else's shipyard. And the shipyard is the contractor, and it's on his premises that the ship is built. And a lot of the differences really stem from that fundamental difference. The buyer, in the case of the shipbuilding contract, simply pays installments and eventually a final installment when the ship is ready and takes it away. He will have a supervision team in the shipyard. The ship will be built under the rules and supervision of a classification society, but it's on the premises of the shipyard. Title arrangements under a shipbuilding contract, the shipyard will generally retain the title to the ship until delivery. Under a civil engineering contract, I think it would normally be the case that the employer on whose premises the building is being built will retain the title to the site and the structures that are erected on it. Termination arrangements under shipbuilding contracts, if you have a default termination where the buyer defaults, the shipyard will retain and sell the ship and set the proceeds off against the price. If it's the builder who goes into default, the buyer will claim repayment of the down payments from the shipyard under a refund guarantee, which will normally be given by a third-party bank. And there is usually no right of voluntary termination. I've noticed particularly in civil engineering contracts that I've been concerned with, and I'm no expert in that field, but there are some crossover contracts as we'll come back to. There is no right of voluntary termination under a normal shipbuilding contract. Under some forms of rig building contract, you do find that, and therefore the work has to be valued, and the buyer can effectively pull out at any stage. But generally, with a fixed-price shipbuilding contract, you will not find that right of voluntary termination. And in civil engineering contracts, in a case of a default, you will normally have to have some provision for the work to be valued, because the work will stay on the premises of the employer. And the employer will be stuck with it, whether they like it or not. If they don't like it, they'll probably have to pull the building down. Another principle which has recently found its way into the courts, which is quite controversial, at least in the shipbuilding space, is the so-called prevention principle. In the case of shipbuilding contracts, this prevention principle, which stems, I think, from a case called Home and Guppy in the 19th century, or possibly even goes back to the 15th century, when the Dowager Queen of England had a claim against a contractor, Queen Joan of Navarre, I think, and the question was, if the employer prevents a contract being completed on time, can then time be set at large? And in the context of shipbuilding contracts, this can be very, very important. But in shipbuilding contracts, this has been very rarely applied, and it's been held in the decided cases on this that the standard forms of shipbuilding contract normally have a complete code for termination and for delay, such that there is no room for application of this principle. In civil engineering contracts, by contrast, it has been successfully invoked in quite a number of cases that I'm aware of, and appears to be much more readily implied. But I won't go into the specific jurisprudence on that. With guarantees, shipbuilding contracts, there will almost always be a refund guarantee for the down payments made by the buyer, so that if the shipyard defaults, it can't deliver the ship on time, the buyer will come along, terminate the contract, and claim its money back plus interest. And that will normally be guaranteed by a third-party bank. Shipyard performance guarantees, as such, are very rare. Performance bonds for the completion of a shipbuilding contract are almost unheard of in my experience, even though, particularly in China, I would say, it's common for a trading house to stand as a joint obligor in the contract behind the shipyard and to allow its balance sheet to be used for the purposes of financing the contract. Buyer guarantees are not uncommon, because very often the buyer is a single-purpose company in a flag of convenience jurisdiction with no assets of its own other than the provided by its parent company. So quite often the parent will be asked to guarantee the obligations of the buyer. I think in civil engineering contracts, various forms of performance guarantee are very much the norm. Well, dispute resolution, and that's, of course, what this seminar is supposed to be all about. Interim measures in an arbitration. In shipbuilding contracts, if a party wants an interim measure, an injunction, say, to stop parallel proceedings in China, where it's claimed that the dispute is subject to arbitration, then normally the parties will go to the commercial court rather than to the arbitration tribunal. In civil engineering contracts, I think it's not unusual for the parties to apply to the arbitral tribunal for relief. So when we come to arbitration and dispute resolution and tiered dispute resolution that Rupert was talking about, I think the setup in shipbuilding contracts is quite different from that in civil engineering contracts. Most forms of shipbuilding contract provide for some form of technical arbitration by a technical arbitrator, maybe somebody like the engineer that Karen spoke about. But the engineer, in this case, does not have the powers that the engineer would have under a FIDIC contract, for example. And in the course of the building of a ship, which might take something like 9 to 12 months, there are often many, many disputes which arise. Most of those are actually settled by the project team on site without having to go to any form of formal dispute resolution. But when it gets heavier and the parties can't agree, it's very rare, in my experience, for them to go to a third-party technical adjudicator or to a dispute board. So it is usually provided for in the contract, sometimes also for the Classification Society to intervene. But the Classification Society will ordinarily only intervene if it's a question of the Classification Society rules which are in issue. Mediation is sometimes provided for in more sophisticated arbitration agreements, but very rarely used in shipbuilding contract context. Frankly, in my experience in negotiating shipbuilding contracts, by the time people come to the arbitration clause, they're usually so whacked that they can't really pay much attention. And so the standard arbitration agreement usually gets stuck in there. And very often you find pathological arbitration clauses because the parties have really not focused much attention at 3 o'clock in the morning when they've struck some sort of commercial deal already. Arbitration, always, and the vast majority of shipbuilding contract disputes go to arbitration if they can't be amicably resolved. We had in the period after 2008 and 2009, when the wheels fell off the international financial system, literally thousands of shipbuilding contract disputes in London, because there were many thousands of ships under construction after an enormous boom between 2003 and 2008, when you couldn't get a slot in a shipyard for love or money. After 2008, nobody wanted those ships. The buyers wanted to get out of their contracts, and many of these landed in arbitration in London. And the other forms of resolution were virtually never invoked. As between institutional arbitration and ad hoc arbitration, most of you, particularly if you've been involved in civil engineering contracts, will be familiar with institutional arbitration in the LCIA or in the ICC. In the case of shipbuilding contract arbitrations, there are a few which have ICC clauses in them, a few which have LCIA clauses in them. Frequently, we find that if the parties can agree on nothing else, what they will do is immediately switch from an ICC arbitration or LCIA arbitration to an ad hoc arbitration on LMAA terms. It's the only thing that they can agree on at that point, because ICC arbitration is seen as long, expensive, and bureaucratic, whereas an ad hoc arbitration under LMAA terms with experienced arbitrators can be dealt with much more cost-effectively and much faster. We have no provision for emergency arbitrators under the rules of the LMAA, and we don't think they are necessary. And why are they not necessary? Because the commercial court provides a very effective means of providing interim relief in those situations where it is needed. In civil engineering contracts, you've already heard in some detail about tiered dispute resolution clauses, including mediation, and I believe that they're common in the civil engineering space. Arbitration, very much the last resort, it would appear. Institutional against ad hoc arbitration, I should think maybe 90% institutional arbitration. Emergency arbitrators, I wonder what your experience is. I know that Singapore boasts a lot of appointments of emergency arbitrators. In the maritime space, they've been found to be a waste of time. And indeed, quite obstructive in some cases to your ability to have resolution by the commercial court. In one case involving the LCIA, an application was made for the appointment of an emergency arbitrator, which was turned down. It was then a similar application was made to the commercial court for similar relief, and the commercial court said, no, you can't have it because it's been turned down by the LCIA. So that was not a very satisfactory outcome. So appeals, this is another area of difference, I think. In shipbuilding contracts, contracting out of Section 69 of the Arbitration Act 1996 is very rare. Whereas, for example, under the rules of the LCIA, it is the default position that there is no right of appeal on a point of law to the commercial court. And in your space, people seem to be happy with that. In the shipbuilding space, and in maritime contract disputes in general, people favour having a right of appeal on a point of law. It was a great debate at the time the Arbitration Act was was put in place in the departmental advisory committee, which advised the government on the legislation, that there was a tradition of appeals on points of law to the commercial court, and those in the maritime area wanted to retain that. It was retained. A lot of people complained that the right of appeal was too restricted, whereas I think in the civil engineering field, people don't particularly like to have a right of appeal on a point of law because they think it extends the process unnecessarily. But in the maritime space, people regard it as an essential safety valve. And indeed, it has been responsible for the further development of much English commercial law. So that's another difference. But there are many more complicated contracts, particularly, where there is a significant crossover between these different types of contracts. And I mentioned 3 objects in particular, where parties may have a choice whether they treat it as being a civil engineering project or a shipbuilding project. And this is probably particularly the case now with wind farms and the emphasis on renewable energy. Do you treat the wind farm or the various components in the wind farm as being maritime objects, particularly if it's a floating wind farm, or do you treat it as being a civil engineering project? And what about, for example, the ships that bring the turbines to be erected on the wind farm? Is that a maritime contract, or is it a part of a civil engineering project? So parties may have to elect there, and there may be inconsistencies which arise from that. If, for example, one of the parts of the project is a FIDIC contract, and the other part of the project is, for example, a traditional shipbuilding contract or a traditional charter party. The sort of objects which you see up on the screen, it looks to me like a semi-submersible rig. Is a semi-submersible rig a ship, or is it a fixed project, a civil engineering project? What about jack-up rigs, which actually stand on the seafloor, for example? Should they be treated to some extent as ships or not? Many of them are, in fact, the subject of shipbuilding contracts in the traditional form. FPSOs, floating production and storage facilities, huge contracts in many cases involving hundreds of millions of dollars. Are they shipbuilding projects or are they civil engineering projects? And which form you choose may have significant impacts on quite a number of things, as I've tried to illustrate, including the dispute resolution at the end of the day. So you have to give all these points, I think, serious consideration in the course of negotiating your project. And I hope in this short term available, I've managed to show you what some of those differences and some of the points on which you need to focus are. So that's the end. That is indeed the back end of a ship, and I hope that that's been of some interest.
Do we have any